Sam. My name is Jessie Tannenbaum. I'm a senior legal analyst with the American Bar Association Rule of Law Initiative. By way of introduction, for those of you who might not be familiar with ABA ROLI, which is our acronym, we are a mission-driven nonprofit entity of the American Bar Association, which was founded in 1990 to assist in legal reforms in the former Soviet Union. We opened our first office in Bulgaria in 1991. Since then, we've expanded and worked in more than 70 countries all over the world, and the ABA consolidated its 5 regional rule of law initiatives into one big rule of law initiative in 2007. So some of you might have been familiar with us under the acronym CELI, the Central European and Eurasian Law Initiative, or any of our other regional initiatives. We're now ROLI. So that will be the acronym I'll be using repeatedly, I'm sure, in this presentation. We are mission-driven, and we have a collaborative model, meaning that we work in countries where we're wanted, where we can partner with local institutions. Our local offices are staffed primarily by local attorneys, bringing in outside experts when needed to provide technical expertise. And we provide advice and support and technical assistance for legal reforms that's both neutral and apolitical. So we aren't an NGO that's trying to overthrow regimes or impose outside change, but rather working with local partners and local government institutions to promote the change that the citizens of the country want to see. I work specifically on our criminal law reform projects and research assessments. And within the kind of broad topic of this panel, the challenges of detention, protecting society, protecting defendants' rights, I chose today to focus my remarks on criminal procedure reform. And I wanted to go first so that I have the best chance of keeping you all awake while I talk about criminal procedure, which I'm not sure is the most interesting topic for everyone. But it's a very important topic, and that's why I chose to focus on it. Criminal procedure affects both states' responsibility to protect society insofar as inadequate procedures can allow recidivism and fail at rehabilitation of offenders, fail to convict guilty offenders, erroneously convict innocent offenders, and also fail to protect the rights of defendants, such as the rights to a fair trial, the presumption of innocence, and so on. In Mexico, for example, faulty procedural rules and laws allow pretrial detention without charge to last up to 80 days, and that's a recent reform. That's a new law allowing people to be detained without charge for 80 days. 80% of convicts, people convicted of a crime in Mexico, have never been brought before a judge, and procedure allows for that. Here in the US, you might be familiar with highly restrictive evidence rules for appeals and death penalty cases, which have allowed people who have substantiated claims of innocence not to get a hearing because they're procedurally barred from presenting new evidence. So I hope that gives you an idea of what the stakes can be when we're talking about criminal procedure reform. In many countries, over-reliance on detention at both the pretrial and the sentencing stages is a major problem. International standards encourage that detention should be a last resort, and that non-custodial measures during investigation and trial and at sentencing should be imposed unless deprivation of liberty is the only punishment that would be sufficient to ensure the purposes of punishment, rehabilitation, retribution, deterrence, and the protection of society. The overuse of detention is often a symptom of a dysfunctional criminal justice system that might lack the protection of rights of criminal defendants and the institutional capacity to impose, implement, and monitor non-custodial measures and sanctions. ABA ROLI believes that overuse of both pretrial detention and sentencing are equally important, and that both must be addressed in order to create effective and lasting criminal justice system reform. So in implementing our criminal law reform programs, we were struck that while there are a lot of academics and governmental institutions and NGOs out there that have heavily documented and evaluated issues of prisoners' rights, including issues like overcrowding, mistreatment, bad conditions within detention facilities, social stigma on offenders, lack of rehabilitation, there hadn't been any organizations conducting studies that sought to directly address the legislative and structural causes of these problems. And so we developed an assessment tool called the Detention Procedure Assessment Tool, the DPAT, we like acronyms, and 2 complementary handbooks of international standards relating to pretrial detention and relating to sentencing, in order to evaluate the procedural and legislative framework that contributes to the overuse of detention and incarceration, as well as the actual practices of criminal justice sector actors charged with implementing detention procedure. It's our belief that by promoting the rule of law through transparent and effective procedural reforms, a country is likely to improve the human rights situation in its detention facilities. And while I'm talking about the DPAT, I do want to acknowledge two of my colleagues here who were instrumental in the development of the DPAT and of these two handbooks. Anita Kokshish is our research fellow. I think I mispronounced her last name. But she's our research fellow from Hungary, was instrumental in developing the two handbooks, which there are handouts about. They're available online. You can pick out the handout with the web address in the back on your way out. And Mary Greer, a senior criminal law advisor, who was my co-coordinator for developing the DPAT methodology and my co-assessor in Armenia, which I'm now going to talk about. Only one of us could be on the panel, but I wanted to make sure that the two of them were acknowledged for all of their great efforts. The detention procedure assessment tool was piloted in Armenia 1 year ago, almost exactly. We piloted in February of last year. It examines both the de jure legislative and procedural framework for detention and the de facto practices under which detention is imposed and implemented. It draws on international and regional laws, norms, and best practices concerning both pretrial detention and sentencing, and evaluates the country's detention system in light of 27 factors that reflect distinct critical issues and stages of the detention process. Information used in the DPAT analysis is gathered during a 2 to 3 week in-country assessment process based upon what we call key informant interviews with all of the local stakeholders in the country who play a role in the detention process at every stage. And the interviews are conducted and the report is drafted by two neutral outside assessors, not locals who are part of the local legal community, but people from outside. Sometimes, in some cases, our assessments are conducted by ABA Relay staff, such as in the case of Armenia. In other cases, we bring in consultants. We also adapted the DPAT methodology to conduct 2 juvenile justice studies, one in Belize and one in Nicaragua, which are being used to inform government and stakeholder working groups in both of those countries who are developing a national strategy for juvenile justice reform. So now that I've kind of given you the framework, I wanted to talk very briefly about one particular case study, and that is the situation of the post-conviction imposition of sentences and alternative sentences other than detention in Armenia. I chose to focus on the post-conviction stage, even though we have a lot of interesting findings about pretrial detention as well, just because given the membership of the panel, I think you're going to hear a lot of great things about pretrial detention from Natalie. But during the question period, if you're curious, I'll be happy to answer questions about both. In Armenia, the sentencing process is at the same time as the determination of guilt. There's not a bifurcated hearing or 2 hearings like we have in the United States, where first it's determined that someone's guilty, then they can present new evidence on what sentence they should receive. Maybe there are mitigating factors, maybe there are aggravating factors. In Armenia, the defense attorney actually has to argue before it's been found that his client is guilty that if the court finds the defendant is guilty, then they should impose a lighter sentence. So you're essentially saying, my client's not guilty, but if he is, please give him probation, which is a system that people are used to, and not everyone identified as a problem, but a lot of problems arise from it because often attorneys just never have the opportunity to make arguments about mitigating factors or factors that should allow for a lighter sentence. Once the court has set forth its verdict, Armenian law does require that individuals should only be deprived of liberty as a last resort, only when it's necessary, and the law does provide judges with criteria to determine the sentence. However, imprisonment is incredibly frequently imposed. We found that the main reasons for this is, one, historic practice. There's a sense, what many Armenians dubbed the Soviet legacy, that detention is just a foregone conclusion, that the prosecutor will always win. The prosecutor always asks for detention. It's incredibly rare for a prosecutor to agree to anything other than imprisonment. And also, and perhaps even more importantly than this mental legacy, is that there's an insufficient framework for the implementation and supervision of alternatives to detention, not just at sentencing, but also at the pretrial stages. There are almost no social services for juvenile offenders or juveniles at risk of offending. There's nothing besides detention, really. There's some outside the court system programs, but really nothing within the court system. The Alternative Sentencing Unit, which is the unit that's charged with supervising offenders on probation and parole, is completely understaffed. They have one office within the Ministry of Justice building and a few regional offices. But, people sentenced to probation, it's really pro forma. And there's almost no mechanisms to supervise people who, have to perform community service, which they call public work in Armenia. One major problem that was identified is that the only basic punishment, there are basic and there are supplementary punishments in Armenia. Basic punishments are the ones that the court imposes directly. Supplementary are if you can't, for whatever reason, fulfill one punishment, like if you can't pay the fine, then public work could be imposed as an alternate to paying a fine. So courts have to order someone they don't want to be incarcerated to pay a fine. Armenia doesn't have a good economic climate. Most judges will know that someone's not going to be able to pay a fine, and so they will just sentence them to incarceration. Or if they do sentence them to a fine, they almost can never pay it. So then the sentence might be switched to public work, but there's no mechanisms to assign them the public work, to find jobs that can be done as public work, to supervise them and make sure they're actually doing the public work. Plus, a lot of people don't want to do public work, frankly. And whether or not that's a good argument, is a separate topic. We have a former attorney who's writing her master's thesis on why Armenians don't want to do public work. So it's a deep question. There's no mechanisms for alternatives. So people end up with their alternative sentences revoked, sometimes without, adequate due process. We found that there's no real, it's not clear whether you're guaranteed a right to a lawyer. Public defenders had never appeared at a hearing to revoke someone's alternative sentence and send them to prison. The law just doesn't make clear if there are any due process guarantees really at all to revoke someone's alternative sentence and send them to prison. As a result of all these challenges, judges are aware in advance that all these challenges to alternative sentences exist. Only 23% of defendants in 2009 across all adult defendants across all categories of cases, from the very most minor misdemeanors to the most severe, felonies, only 23% received an alternative sentence, and the rest were sentenced to some form of detention. As I mentioned, even with those 23% that are sentenced, there's then appellate procedures. The prosecutor can appeal a sentence. And so, the number is actually probably lower, but we don't have the statistics. We weren't able to obtain statistics for how many times the prosecutor appeals and then the sentence is reversed. But when you're talking about everything from, reckless driving to getting in a bar fight to murder, 23% is a fairly low number. Just to touch on Sam's questions, what we're doing to make sure that this study doesn't just sit on a shelf. This study was implemented in conjunction with a working group organized by ABA Roli that consisted of 4 leading Armenian criminal law attorneys from both government and academia and I believe private practice as well. And they collaborated with us in the assessment. They assisted us in holding a series of roundtables and training both on Armenian law and international standards. As a part of that, we identified this need to publish these handbooks that I mentioned, have them translated into Armenian, because that was a major problem, that attorneys just didn't have access to international laws in the Armenian language. And our working groups also drafted 2 white papers and are working to draft procedural and legislative reforms, reform the criminal procedure code and the way that the trials are carried out in Armenia. And then we also have some programming plan going forward, which I'll be happy to take questions about at the end. But the main recommendations were to define a separate guilt and sentencing stage, to increase the staff and resources for monitoring alternative sentences, to clarify the conditions under which public work can be replaced with incarceration, to change the law to allow public work to be directly imposed instead of only as an alternative when someone doesn't pay a fine, and to also consider, because there also exists probation as an alternative to incarceration, but probation doesn't carry any requirements with it other than just checking in. There's no community service. And so consider making probation a more robust alternative that judges will actually consider by having it actually have some actual teeth, as opposed to just, you're not going to jail. You have to sign in once a month. So thank you, and I'll be happy to take questions about anything I've said later on.
Okay, thank you very much, Jessie. I didn't properly introduce Jessie, but she properly introduced herself as Senior Legal Analyst of the ABA Rule of Law Initiative.